SwayamPrabha. Digital India. Educated India.
Welcome back to the lecture number 17th of the course on Law of Torts, Consumer Protection and Motor Vehicles. In this lecture, we will discuss or continue our discussion on the area of consumer protection. In the previous lecture, we discussed about how consumer protection evolved and how the laws on consumer protection was developed, what are the objectives of these laws, and what are the institutional framework that has been created for the purpose of fulfilling or implementing the legislative objective. In this lecture, we will go into a little more details of the acts. In the previous lecture, we discussed the salient features, more of like an overview. In this lecture, we will go into some of the details as to some of the very important or significant features of consumer protection. And we call this lecture as wrongs against consumers and its remedies. So, principally the lecture has been designed to give you a snapshot as to what are the different types of wrongs that can be committed with violation of consumer rights against consumers, as that has been recognized under the current legislation. The topics covered in this lecture are following: definition of consumer goods and services. So, because we are discussing the subject of consumer protection, and as I started my lecture on this area of consumer protection saying that everybody is a consumer. So, that makes a slight interesting observation or point of analysis that whether all types of consumers are covered or the act specifies a particular class or type of consumers to be covered under the law. And of course, goods or services that are related to consumers' main consumption. So, what are the goods and services falling under the Consumer Protection Act and how they are defined? So, that will be the first topic. Following that, we will see what are the ways consumer rights are violated. We have discussed about the 7 rights in the UN Declaration and the 6 rights in the current Consumer Protection Act. Now, in this chapter, we will discuss what are the ways in which consumer rights today are violated and some of the major important aspects of violation of consumer rights and how they are to be tackled. So, unfair trade practice and restrictive trade practices, these are the 2 major areas will be broadly discussed, and other areas will also be discussed. So, starting our discussion with this very fundamental question that who is a consumer. Now, in a very simplistic manner, if we try to understand, any person who consumes is a consumer. Now, the question that emerges is that, for example, if a person is not paying any money for the purpose of his consumption, will he be also treated as a consumer? When a person who is a very big entrepreneur, seller, manufacturer, or owner of a showroom, he also purchases things, will he be considered as a consumer? Or Consumer Protection Act only deals with the class who are practically consuming for their purpose by paying some money and will not include any consumption when it is done for any industrial, business or commercial purpose. So, how do we define? So, broadly the Consumer Protection Act defines consumers in 2 categories: consumer of goods and consumer of services. Now, with reference to consumer of goods, the Act says that any person who buys or agrees to buy or who is a user of such goods is a consumer. So, this buys or agrees to buy is an important point. buys or agrees to buy means that a person to be a consumer of goods has to avail or purchase a good or take good in his possession on payment of some sort of a consideration. Some consideration in lieu of that consumption must be there. So, any person who is consuming without consideration will not come under the purview of the consumer of goods. So, any purchase which is made free of cost is not coming within the concept of consumer defined under the Consumer Protection Act. So, consumption without payment is left out of the Consumer Protection Act's purview. So, any person who buys or agrees to buy goods or for a consideration is a consumer of goods. Similarly, with reference to services also, any person who hires or avails any services, hires or avails. So, hires or avails means again there is a consideration. So, even in case of services also there is a question of consideration that is involved. Who hires, that means who takes it for lieu of some payment or some consideration, or avails with the approval, availing somebody who has to purchase or with or in lieu of consideration has to procure the service, and with the permission of that person, any other person who avails, they will be treated as consumers. Now, the second point is any user of such good. Now, user here whether will include any person who is using free of cost? No. User of the goods will principally include that when A has purchased something and with the permission of the A, B is using, then B will be treated as a user of the good, and in case of service he will be treated as a beneficiary of such service. Now, to give an illustration, for example, if my father purchases a mobile phone and gives it to me and as a gift or present, and I continue using it, and there is some defect in that mobile phone. Now, for that purpose, will I be treated as a consumer? Yes. Why? Because my father has purchased the product by paying consideration, that is paying the amount of price. So, price is a consideration, and then with his permission I am using it. So, therefore, I am using it with the permission of a product which has been purchased by consideration payment. So, I am a user. Okay. Similarly, when it comes to beneficiary of service, say for example, A is paying the cost of the hospital bills of B. Now, B is a dependent, say B is a minor child. So, A, his father, is paying the bills of the hospital cost for B. Now, therefore, B is principally a beneficiary of such service. However, here he is a beneficiary, but somebody is paying for it. He is not beneficiary of pure free or pure what is called charitable service. He is beneficiary of a service which has been purchased by someone in his favor, and that makes him also a consumer. So, therefore, what is important to note here is that any person who is using a good or availing a service without payment of any amount of money is first not coming within the definition of the consumer. Second important point is that the definition of consumer both for services or for goods makes a exception that when goods are purchased for commercial purpose or services are availed for commercial purpose, they cannot be included within the definition of consumer of the Consumer Protection Act. So, two major distinction we see, two major conditions we see in the definition of consumer. First, in order to be a consumer, you have to pay some consideration, or you have to avail or benefit from the service or goods which has been purchased by someone in your favor. So, any free of cost payment of goods or any free of cost availing of service is not entitling you to be a consumer under the Consumer Protection Act. Second distinction, second condition is that when anybody is purchasing goods or availing services or hiring services for commercial purpose is not coming within the definition of consumer. Now, availing services for commercial purpose or hiring services for commercial purpose, how it can happen? For example, I am owner of a movie theatre, a very big movie theatre, Inox, and I have hired one group of persons for providing security services to my facility. Now, there is some deficiency in their service as per the terms of the contract. Now, can I approach the consumer court for deficiency of service against the security company? No. Why I will be excluded? I will be excluded because my hiring of services have been for a commercial facility or by purpose is a commercial purpose, right. Now, if I was a owner of a house and for my protection of the house I had hired a security and the security was sleeping at night and thieves came and stole whatever valuables from my house. So, there was a deficiency on the part of the security guard because he is obviously not supposed to sleep when he is in duty to secure the house. If he is doing that, it is a deficiency of service. So, if there is a deficiency of service of the part of the security guard, because here there is no commercial purpose, I can avail the relief of I can avail the benefit of going to consumer court. But if I am owner of a Inox multiplex theatre, movie theatre, and I have hired a security services from a security company and there is a deficiency, then I cannot approach consumer forum. There are other forums, but I cannot approach consumer forums because it is hired for commercial purposes. Now, one important debatable question has always been surrounding the definition of consumer is what is commercial purpose? How do you define that this is a commercial purpose? And it becomes very difficult to blur or very blurred when in some niche areas. For example, a person is a restaurant owner and he is a very small entrepreneur and he has hired a security for the purpose of protection of his equipments and other things in that small facility, and due to the lapse on the security there is a burglary. So, can he go? There is a question. Similarly, there can be a question, for example, a person who is owner of a taxi, can he go to consumer forum because ultimately he is plying. So, that I will come. So, commercial purpose is something which is not very clearly understood. The Act says that whether the purpose for which the person has brought the good is commercial purpose within the meaning of the definition of the expression consumer in section 2D of the Act is always a question of fact to be decided in facts and circumstances of each case. So, there is no clear straitjacket rule that this is commercial purpose and this is not commercial purpose. In each case, based on the factual matrix of the case, it will be determined that whether the person is engaged in a commercial purpose or is not engaged in a commercial purpose. There is no straitjacket rule. Secondly, a person who buys goods and uses them himself exclusively for the purpose of earning his livelihood by means of self-employment is within the definition of the expression consumer. Now, within commercial purpose, the definition of consumer makes a further exclusion. Now, it says that yes, commercial purpose overall is barred. So, anyone who is consuming for the commercial purpose does not come under the ambit of definition of consumer of the Consumer Protection. However, when it is a commercial purpose, but the purpose is for the earning of his livelihood or means of self-employment, he will of course fall within the expression of consumers. So, that is why I said the very niche area. Now, it is very easy to make out, for example, say the example that I gave at the outset Inox Theatre. I am owner of Inox Theatre. So I have engaged a security company. Of course, it's a commercial purpose. So there is much not to debate. Facts are very clear. Nobody is owner of a Inox for entertainment purpose for his personal reason, right? So therefore, it is definitely a commercial purpose. But the problem happens that if he is a taxi driver and he has purchased a taxi, plying it for the purpose of taxi service. Now, of course, the taxi is the sole opportunity of earning his livelihood or self-employment, and therefore, although it is a commercial purpose for which he has purchased the taxi, but any deficiency or defect in the taxi or its services, he can lend that to the consumer forum, because he will come within the exclusion to the exclusion clause, which is earning livelihood or self-employment. But the problem arises that if now this person who was earlier having one taxi and plying all by himself, no problem, but later he buy one more taxi, and the second taxi now he is not plying all by himself. What he is doing is he is engaging a driver or engaging his one family member, his brother. Now, of course, that is livelihood also, but will that come? Now, of course, there is an open question. Even Mukesh Ambani from the whatever earnings from Reliance, is his earning of livelihood or for his purpose of earning from his employment. But of course, Mukesh Ambani will not qualify here for earning his livelihood exclusion. Earning his livelihood exclusion or self-employment will only qualify those very nominal small entrepreneurs or very small business houses or very small opportunities of commercial world who are largely depending their livelihood and their employment based on that. Say somebody starts a Xerox center. So a Xerox machine is purchased, and from the Xerox machine it is his self-employment. He is self-employed and he is doing it. Now it is not that 24 hours he has to do it. In some part of the time he may employ somebody. Now employing somebody will not remove him from the jacket of self-employment, because if it is a small entrepreneurship it will still qualify. So there is this debatable question as to who qualifies as consumer with reference to commercial purpose and the exclusion to this commercial purpose, that is when somebody is exclusively doing it for the purpose of earning his livelihood or means of self-employment. And here also there is no straitjacket rule. As in commercial purpose it is said that it will be based on facts of each case. Similarly, here also there is no straitjacket rule. Now, in a leading case before the Supreme Court, where the question was what means exclusively for the purpose of earning his livelihood, the name of the case is Chima Engineering Service versus Ranjan Singh. The Supreme Court had an opportunity to define what is self-employment or look at what is the meaning that can be assigned to this phrase. And the courts observed, and I quote, "The word self-employment is not defined. Therefore, it is a matter of evidence." Same, as in commercial purpose, it is not defined, it is matter of fact to fact, case by case basis. Similarly, here also court says self-employment is not defined. There it is a matter of evidence. Unless there is evidence and on consideration thereof it is concluded that the machine was used for self-employment to earn his livelihood without a sense of commercial purpose by employing on regular basis the employee or workman for trade in manufacture and sale of bricks, it would be for self-employment. So what the court says, in this case the question was about a brick field. So whether the brick field qualifies within the concept of self-employment or not, and get the benefit of approaching a consumer forum for resolution of its consumer dispute or not. So court said that unless there is evidence on consideration thereof, it is concluded that the machine was used only for self-employment to earn his livelihood without a sense of commercial purpose by employing on regular basis the employee or workman for trade in manufacture and sale of bricks. It would be for self-employment. Manufacture and sale of bricks is a commercial way, may also be earned livelihood, but merely earning livelihood is in a commercial business does not mean that it is not for commercial purpose. Self-employment connotes altogether a different concept, namely he alone uses the machine purchased for the purpose of manufacture by employing himself in the working out or producing the goods for earning his livelihood. He includes the members of his family. Whether the respondent is using the machine exclusively by himself and the members of the family for preparation, manufacture and sale of bricks, or whether he is employed any workman, and if so, how many, as a matter of evidence, the burden is on the respondent to prove them. So, what the court is saying that, see, I have a machine and the machine's purpose is to produce brick, and obviously the brick that is produced I am not going to use for my own purpose, I am going to sell it. So, moment this relation of the transaction comes, it is a commercial purpose. Now, the question is that just because this is a commercial purpose, will it disentitle me from getting the benefit of the Consumer Protections Exclusion Clause? No. What has to be seen is that in this production process of brick using the machine, who are engaged? If it is only he is engaged with support of some family member or few or even one or two labor, he will come within the arena of self-employment and will be protected or will come under the ambit of the consumer. But if it is a machine which is where employs a number of workmen and a huge quantity of brick is produced and it is sold, then it will not come. So, all these things can only be determined based on what are the evidence available in that case, and based on the evidence it will be determined. So, therefore, what we understand, if we sum up from the discussion that we had till now, consumer is a person who either buys or agrees to buy any goods, or hires or avails any service, or any user of such good with the permission of the person who has purchased it, or any beneficiary of service with the permission of the person who has purchased it, will be a consumer. However, if such is for commercial purpose, it will not be included, but if the commercial purpose is only for the purpose of earning his livelihood or for mere self-employment or by means of self-employment, it will again be excluded and it will come under the domain of consumer protection. So, basically if we say who does not qualify as consumer, so there are few categories who will not qualify as a consumer. First, any person who does not pay any consideration for purchase of a good or availing any good or hiring any service or availing any service is not a consumer. Any person who is using goods without approval of the person is not a consumer. Any person who is purchasing or hiring goods or services for commercial purpose is not a consumer. So, therefore, these are the broad class of people who will be excluded. So, it is very clear that the definition of consumer in the Consumer Protection Act is given a very technical meaning. And why is this technical meaning? The simple reason is that if everybody was included, then it would have been difficult for the law to achieve its purpose of speedy redressal, because the law was also creating a special forum where consumers can only go and seek redressal of the consumer grievances. Now, to ensure that this forum is restricted only to consumers, a limited class of consumers, that is why the law has given a technical definition to consumer. It does not include everyone, because otherwise in a literal term everybody who consumes is a consumer, but it has given a technical meaning where it has restricted number of people from the definition of consumer. Now, moving forward, we have seen goods and services. So, what is meaning of goods? According to Consumer Protection Act, every kind of movable property including food items defined under the Food Safety Act are goods. However, according to the Sale of Goods Act, electricity can be also a good, but Consumer Protection Act does not include supply of electricity or sale and purchase of electricity as a good under the act. It says it is coming under service, but not goods. But bonds, bank security deposit, security documents, shares, they are treated as goods under the Consumer Protection Act. Second, what is service? Now, with the definition of goods there is not much controversy, but with the definition of service there has been a slight bit of debate. Now, if we look at the definition of service, the definition is in three parts. The first part, it says service of any description which is made available to potential users, but not limited to the provisions of facilities in connection with banking, financing, insurance, transport, processing, supply, electricity, other energy, boarding, lodging, housing construction, entertainment, amusement, purveying of news and other information, but does not include rendering of services free of charge or under the contract of personal service. So, if we anatomically divide this and see that the service definition we just read has three parts, and the Supreme Court in Lucknow Development Authority said that the first part is the main part. It is called main part because it is the explaining what is service, so explanatory nature, and it says service is defined to be service of any description which is made available to potential user. So, service can be any description of service, there is no limitation. The law does not limit, it can be any definition or any limitation. And then the second part is the illustrative part where the law is giving some examples of kinds of service that will come. For example, banking, finance, insurance, transport, supply of electricity, etc., etc. And in the third part, however, the law excludes certain types of services. Now, in the first part law says any service, second part it gives example, and the third part, however, it clearly exempts certain category of services falling under the Consumer Protection Act. What are these? One is free service. So, any service which is rendered free of charge cannot be included. And second, contract of personal service. Now, this is an important point, contract of personal service. Contract of personal service means when you are engaging a servant and the servant is supposed to work under your direction. Now, in that case it is a contract of personal service and it will not come under the purview of Consumer Protection Act. Now, what types of services are excluded? As I said, two broad types, delivered free of cost and services pursuant to contract of personal service. Now, moving forward, what are the ways in which consumer rights are violated? Now, in the modern world, if we see, these are some of the illustrative ways in which consumer rights are getting violated. Supply or sale of spurious or hazardous goods or services, using fraudulent weights and measures, sale or supply of defective or substandard goods and deficient services, making false and misleading statements and promises, misleading comparative communications, adopting anti-competitive, deceitful or unfair methods in marketing or trade practices, abuse of dominant position in the market. So, these are some of the illustrative ways in which consumer rights are violated or where consumer requires protection. Now, if we look at all this, we will generally find broadly there is a defect. So, defective goods, hazardous goods and services of course does not come under directly defective goods, but hazardous means anything that is harmful to human environment, natural environment, animal life, ecology, hazardous. And spurious means which are poisonous. So, spurious hazardous goods, apart from that defective goods. So, what is defective goods? The word defect has been defined in the Act as a fault, imperfection, shortcoming in the quality, quantity, potency, purity or standard which is required to be maintained by or any law for the time being in force or under any contract express or implied or as it claimed by the tender in any matter whatsoever in nature of any goods. So, you go to buy an air conditioner is a goods, it is promised that this will happen, you buy, you bring it back and you find that it is not performing as it is promised. So, therefore, there is a definite defect, and if this defect is not repairable, then it is a defective goods. So, it falls within the category of defective goods. So, defective good is one. Then deficient services. What is deficiency services? Now, law says any fault, imperfection, shortcoming, inadequacy in the quality, nature and manner of performance which is required to be maintained by or under any law for the time being in force will be considered as a deficiency of service. Okay. I will again repeat my I will repeat to help you to understand. Any fault, imperfection, shortcoming, inadequacy in the quality, nature and manner of performance which is required to be maintained by or under any law for the time being in force or has been undertaken to be performed by a person in pursuance of a contract or otherwise in relation to any service. Say for example, a doctor conducts a surgery and after the surgery is over, the patient does not get well. He is supposed to get well. The purpose of the surgery is to see that the patient is treated. He does not get well, rather his condition worsens. And then it is found that at the time of surgery there is a surgical instrument called mop. The doctor has left it inside the body of the patient and has stitched. Now, this is of course not the manner or perfection in which the medical service of surgery should have been conducted. So, therefore, the doctor is liable. Now, this was a question before the courts that whether medical professionals can come under the service definition, because if you look at the definition, the illustration clause, it does not say about medical services. It includes those which does not say medical services. So, the question was whether medical services can come. The court said yes, and the court said see, if we look at the first part which is the explanatory part, it clearly says that any type of service can come, and the second part is just the illustration of some, but the third part clearly excludes those which the legislature intended to be not part of the definition. And if they intended medical service to be the nature of service which to be intended to be included, then it would have been there. So, second argument was made is that medical service is a contract of service, because personal service, because the doctor does not do anything other than what the patient asks. So, that argument was also not accepted by the court saying that yes, the patient asks the doctor to conduct surgery, but how the surgery to be conducted, whether the surgery to be conducted at that point or later time, all these decisions are taken by the doctor, not the patient. So, therefore, how can you say it is a master servant relation? Doctor patient is not a master servant relation. So, therefore, there is no contract of personal service, it is contract for personal service. Okay? So, contract of personal service argument also did not stand. So, therefore, this is the manner in which you have deficiency of service. There is n number of examples of deficiency of service. For example, a insurance company failing to pay the coverage amount at the time of the claim within reasonable time. A bus, railway or bus, there is a delay, an inordinate delay, that is a deficiency of service, without justification of course. Then courier services delivering letters or couriers in a different address, deficiency of service. So n number, banks when there is a fire and valuables of a person gets damaged and the fire is due to negligence of the bank employees, then it is deficiency of service. So, therefore, there is n number of examples that can be given of deficiency of service. Now, moving to the third aspect, which is unfair trade practice. Now, what is unfair trade practice? Now, Supreme Court in a number of cases have said that what comes within unfair trade practice. Supreme Court says that it has to be a trade practice first. The practice in question is a practice of trade or practice connected with trade. If it is not connected to the trade or not associated to the trade, it is not coming within the concept of unfair trade practice first. So, it has to be a trade practice. Second, the trade practice should adopt any one or more trade practices as contained in the clause of COPRA. Initially, the view was ambit of unfair trade practice was defined under COPRA is exhaustive, but now Supreme Court says that it has been inclusive one and not exhaustive. So, in the Consumer Protection Act, there is a list provided as to what are the trade practices which according to the Consumer Protection Act is an unfair trade practice. So, initially the view was that this list is exhaustive. So, any practice which is trade practice and which is coming under that exhaustive list of the COPRA was considered to be trade practice. But later Supreme Court said no, if it is a trade practice and it may not be within the list of the COPRA, also then it can qualify as a unfair trade practice. For example, when the trade practice used for the purpose of promoting trade, sale or supply of any goods or provisions, or the loss or injury caused to the consumer by adoption of such trade practices due to absence of elimination of restriction of competition or otherwise. Now, say for example, in this case Maruti Suzuki versus Rajiv Kumar Lomba, what happened is that Maruti Suzuki took advantage of a Supreme Court decision where it says that every Maruti car which is to ply in metropolitan areas has to have a Bharat stage 4 catalytic converter. Now, the catalytic converter's price was 50,000. Now, this particular gentleman filed a case against Maruti Suzuki where he purchased the Suzuki and used it in Chandigarh, and the Maruti Suzuki company said still you have to take the catalytic converter. Now, he said catalytic converter is only applicable to metropolitan city. Why are you implying it on me? Because I am not driving in metropolitan city. Maruti said that we cannot remove. But it was actually found that the vehicles which were sold in Chandigarh did not have catalytic converter. So, therefore, it was considered as a trade practice or associated to the trade practice, and it is for the purpose of promoting trade, sale or supply of any goods or provisions of any services or loss or injury caused to the consumer by adoption of such trade practice due to absence of elimination of restriction of competition or otherwise. So, that is what comes under unfair trade practice. There is an enormous number of examples of unfair trade practice. I am not going into all the details, but there are plenty. The next category is restrictive trade practice. Now, unlike unfair trade practice, restrictive trade practice in general is one which has an effect on preventing, distorting or restricting competition. So, in particular, a practice which tends to obstruct the flow of capital or resources into the stream of production is a RTP. Likewise, manipulation of price, conditions of delivery, flow or supply of market may all affect in imposing consumer unjustified cost or restriction as regarded as restrictive trade practice. If we go and see some of the usual ways in which RTP is done, so one or two. One is refusal to deal. This is one method. What happens here? The practice of refusing to deal with consumers or suppliers with effect of preventing them from dealing with a rival. For example, a newspaper refuses to carry advertisement from companies that were also running ads in local radio station. So, there are two ways in which you can advertise in a particular place. One is newspaper and one is local radio. Now, the newspaper has much larger reach. So, the company wants to advertise in the newspaper, or it also wants to advertise in the local radio. But the newspaper says no. If you want to use our medium, then you cannot use the local radio. So, that is what is called refusal to deal. That is a form of restrictive trade practice, because what it is doing? It is affecting the business of the local radio, and also it is distorting competition, creating a market only for own. Second type, tie-up sales. A company providing a product or service on condition that the consumer purchases some other product or service. So, a company has X as a very popular product and knows that there is a great market demand, but the product Y, it has newly launched. Now, it does not know that whether consumers will buy, and there is a competing product of Y which is very having large market presence. So what it does is, it says that I will sell X, only condition is you have to buy Y also with X. This is tie-up sale. This is a restrictive trade practice. Again, the effect is not only to the consumer, effect is to the economy, because this is distorting competition, affecting the other players. Similarly, price discrimination. I am just going through some, I am not discussing all. Price discrimination, charging customer different prices for same product or services based on the seller thinks that he can get customer to agree upon. So sometime I give more, sometime I give less, based on what I can convince, and that's highly wrong practice. It's a restrictive practice. Resale price maintenance, a practice in which manufacturer fixes the price for the resale of the brand product and the retailer is not allowed to sell at a lower price. Now, price discrimination, for example, here it is a form of a RTP where charging customers different prices for the same product or services based on what the seller thinks he can get from the customer. Now, this is a practice which you can see affects everybody, affects the economy, affects the customer, affects the competitors. Similarly, for example, resale price maintenance. Now, a practice in which the manufacturer fixes the price for the resale of a brand product and the retailer is not allowed to sell in a lower price. Now, what it does is that, say for example, if I have the manufacturer can fix the initial price. Now, resale price can vary based on various factors, right. Now, here the manufacturer is also trying to fix the resale price. So, basically it is trying to take use of its maybe it has a larger share in the market, it knows that customers have a brand equity. So, taking advantage of all this, it is trying to distort the competition and is trying to affect the consumers base as well as others in a large extent. Predatory pricing is one of the most common and most distorted form of RTP. Predatory pricing is, it means that is a practice of setting prices for a product unrealistically low in order to eliminate competition. Its goal is to create a monopoly. For example, say X, Y, Z, 3 airlines were in operation. Now, a new airline A enters the market. Now, A has somehow a huge source of investment behind it. Now, what it does is that it starts selling the tickets of the flight in a throwaway price. And of course, everybody wants to travel cheap. So, of course, everybody goes and flocks to buy the ticket of that company. But what happens is, over time the others, because they are not getting adequate customer base, so they slowly move out of the market. Now, after they move out of the market, now A is the only. So, X, Y, Z, the 3 other airlines have now been thrown out of the market because they could not find a survival means and they could not compete. Now, A is the sole. Now, A suddenly raises the price to such a level which was never before when these 3 companies were working. And because there is no other competitor, now the customers have no other means but to only take the service at the price which is offered by A. This is what is a predatory pricing, and this predatory pricing is done when companies with huge wealth base or huge investment base enters into the market, try to capture the market totally, create a monopoly. So, that is something which should not be allowed. Area restriction is another form where dealers etc., dealers, distributors are restricted to sell beyond a particular area, which causes a serious lack of competition. So, there are these different modes by which restrictive trade practices happen. So, if we take 2 concrete examples between restrictive trade practice and unfair trade practice, we can see how they are different. Now, in Maruti versus Rajiv Lumba case, what I said, that Maruti there, what made a compulsion is by misleading, saying that Supreme Court has said catalytic converter Bharat stage 2 is necessary. So, therefore, every vehicle that we are manufacturing in India has a catalytic converter and it is a necessary part. So, it is trying to mislead to make gain, because catalytic converter without catalytic converter the prices are less, with catalytic converter the prices are more. So, therefore, it is trying to take advantage of a Supreme Court judgment which is operating not exactly all over India, but to limited space, but Maruti company is taking advantage of that judgment to say that we are going to give this judgment a all India implementation, which is not necessary. Now, you can see here, of course, this also distorts the market, but it is by a way of misleading. Another example of unfair trade practices, common example, there is a shop which advertises that all goods are sold at 50% discount. Now, when you arrive there, you see that only some very few number of clothes are stacked in one particular corner and their top written 50% discount, and they are in a very bad shape, etc., etc. And rest of the shops are in different kind of price. So, 5%, 10%, no discount. Now, when you ask, they say, sir, you are late. We advertised on this day and everybody came and we are now out of stock, this is only left. But rest of our stock is fresh stock, with this discount you can buy. Now, invariably because you have gone there with a intention to buy, you will buy. This is called bet switch. Now, this is a misleading. You are they're misleading and taking advantage. Now, sometimes somebody promises that if you buy this product and you will get a price, but ultimately they don't have any intention to pay any price. That's misleading. Okay. So, unfair trade practice is somewhere largely related to misleadingness or taking the lack of information asymmetry advantage, or all these aspects. Sometimes selling over the MRP, these are types of unfair trade practice. But restricted trade practice, practices that I just discussed, has a direct impact on the competition and the economic system. For example, Maruti company started taking booking of a particular vehicle and it is supposed to deliver those vehicles on within 30 days. Now, those who booked the vehicle on the first week of March, they were supposed to get the vehicle by 31st March. Now, they saw that the information came to Maruti that in the union budget, prices of certain types of motor vehicle parts will increase. So, that will help that will impact on total increase of the price of the Maruti vehicle. So, what they did is, now they stopped the production. They slowed the production or stopped the production, and when the customers ask, why is my delivery not coming? Sorry sir, we are not able to deliver, too many customers, these excuses. But end of the day, what they are trying to do is that after 31st, if they now deliver, now they will say, see, the agreed price which we entered into the contract that point of time was the pre-budget price, and post budget the price has increased. So, now you have to pay the increased price. So, you can see the whole idea of doing the trade practice is quite different in these two. So, therefore, between unfair trade practice and restrictive trade practice, there is a difference, and this difference is that in unfair trade practice, it is primarily a deceitful or misleading representation of goods and services which portrays a false image of the product. Information regarding its utility, quality, standard, style, price, services, they are twisted. But in restrictive trade practice, traders try to change the flow of money in the market in order to maximize their profit, to gain an upper hand in the market, predatory pricing. In RTP, independent sellers hike their collective profits by limiting supply, by controlling selling prices, the one that I said right now. or the prices of purchased inputs. So, this is a primary difference in unfair trade practice and restrictive trade practice. So, it is not misleading, it is by way of changing the flow in which the market has to work. The competitiveness of the market is distorted and it affects everybody. So, that is the distinction between UTP and RTP. Now, among the 5 things that I have discussed consumer wrongs, one is sale of spurious or hazardous goods or services, sale or supply, then defective goods, deficient services, RTP, UTP. Now, all this was discussed in the 1985 Act, 86 Act, but in 2019 Act there were 2 areas which were earlier considered to be part of UTP, now they independently created as consumer wrongs. One is the Unfair Contract Terms Act terms, and the second one is misleading advertisement, and this was relating to the gaps, as I said, identified in the Act, because they are most rampantly happening, yet the 1985 Act, 86 Act had limited coverage. I will not say that it was not able to cover, but had limited coverage. So, a more strengthened mechanism was required. One was of course a strong implementing authority. So, the Central Consumer Protection Agency we discussed earlier, authority we discussed earlier, that was introduced, and second, the whole idea of defining them as to what amounts to unfair contract or misleading advertisement was very clearly made in this 2019 Act. So, 2019 Act, in terms of what amounts to unfair contract, it was defined as that a contract between a manufacturer or trader or service provider on one hand, a consumer on the other hand, having such terms which causes significant change in the rights of such consumer, including following, namely A, requiring manifestly excessive security deposit to be given by consumer for performance of contractual obligation. Second, imposing a penalty on the consumer for breach of contract thereof, which is wholly disproportionate to the loss occurred due to such breach or other part of the contract. Third, refusing to accept early repayment of debts on payments of applicable penalty. Fourth, entitling a party to contract to terminate such contract unilaterally without reasonable cause. 5, permitting or has the effect of permitting one party to assign contract to determine of other who is a consumer without his consent. And last, imposing on consumer any unreasonable charge, obligation or condition which puts such consumer in disadvantage. Now, earlier it was a prevalent norm that banks, when they gave loan, if you want to repay before the actual time of repay, the bank would actually take penalty. Now, understand this, I am trying to pay earlier to my time, so I am trying to benefit it, you are not happy. Rather on the contrary, because I am trying to pay early, you are punishing me. So, that was part of the contract, and when banks were asked this question, they defended that it was part of the contract. But this very thing was unfair, because A, if the customer was given a choice, will he agree to this contract? No, it was a unilateral contract and it was a contract handed over by the bank. So, therefore, they had no opportunity to not accept it, and therefore, they were forced to accept it. So, that is unfair contract, and unfair contract act now clearly plays an important part in consumer relief. Already Supreme Court has decided 2 important cases relating to building and construction contracts, where it has held those contracts unfair. Last, misleading advertisement. Now, one of the major problem in Indian consumer market is misleading advertisement. It is rampant, and to curb this menace, a strong definition and penalty was necessary, which has been achieved in 2019 Act. So, 2019 Act says what is misleading advertisement? Falsely describing product or services, giving false guarantee, conveying an express or implied representation which made by the manufacturer or seller thereof constitute an unfair trade practice, and deliberately concealing important information. Now, misleading advertisements are for the purpose of playing with the psyche of the consumer. say Bonvita claims if you drink Bonvita, your son will be much more intelligent and clever. Who has proved it? Is there any scientific evidence? They will not able to say. So, but they are trying to play with the psyche. So, this kind of advertisements are barred, very stringent penalty including prison terms have been provided. So, therefore, you can see that there are several aspects of ways by which consumer rights can be violated. Now, we can say it in this way, see it in this way as consumer rights violation. We can see it as wrongs against consumer. Whatever way you see, I called in this lecture as wrongs against consumer. So, there are types of wrongs that are committed against consumer. For example, the 5 types, 7 types we discussed, which is elaborated in the 2019 Act, sale and supply of spurious goods and hazardous goods, defective goods, sale of supply of defective goods, sale and supply of deficient services, unfair trade practice, restrictive trade practice, unfair contract terms, misleading advertisement. So, these are all wrongs against consumer, and therefore, they have been defined, grounds have been very clearly laid down, and a mechanism has now been established to, when consumer suffers this wrong, enforce their right and get remedy. That will be discussed in the next class, next lecture, which is on the consumer forum, the special forum which is the path breaking part of the Indian legislation to achieve justice for consumer in a timely and a cost effective manner. So, I thank you again for attending this lecture. I hope to see you in the next lecture. Thank you very much.